Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Good evening, folks. Welcome to the Wednesday night call-in show with your host Kirk Pendergrass, John Gentry, and Christopher Hallett over there. How you doing tonight, brothers?
Good evening, everybody. Good evening, Kirk. John?
I'm doing good tonight, man. How are you guys?
Busy.
Still firing it up, right?
Hot and tired.
Got that right, boy. Been a crazy week.
Hot and tired. I can't even say I was rode hard and put away wet.
Yeah. I'm feeling like I was run over hard by a freaking, armored car, man. Talk about no mercy.
It's funny how Idaho weather is, man. I swear we have like two seasons. We have cold and hot. Summer and winter. That's it. We get this little tiny bit of a spring and a fall, but it just goes bam, right from 40s and 50s right into 80s and 90s.
Right. Well, that's like here in Florida, we have the two seasons. We have hot and oh my God. So.
Well, and you're right there by the ocean, so at least you get, that cool, humid breeze.
Yeah. Well, when it feels like it. And then, of course, there's the two extremes, right? It's either just hot, moist air or, hurricane, whatever the hell its name is, coming right up your skirt. So, it is what it is.
Yeah, where I'm at here, Idaho's a high desert. We're at 30, like right here in town, we're at like 3,000 feet.
Wow.
And just 45 minutes from here, right up the hill here, then you at the top of what's called Bogus Basin, there's a ski resort there, 6,000 feet.
Oh, Lord.
So, yeah, we got lots of tumbleweeds and sagebrush and desert and rivers. We got Snake River, the Boise River, and lots of mountains.
Started working on an extraordinary writ. Let the Supreme Court know that we, the people, are coming. And I'm going to say, you need to order the clerk's office to docket it as we present it, regardless of what your rules say. And we'll see what they say. But it's first shot, number one, getting started on it.
Well, yeah, I mean, this is the whole point behind the thing is the rules are just by design, again, guidance documents, policy, okay, because the judicial branch doesn't have the power to make law. So your rules don't actually apply. Exactly.
And we're going to go through all the arguments that we've talked about already. We have an unalienable, indefeasible right to reform our government. That's exactly what we're doing. And they can't put a lien on that and say, well, you got to follow this rule. But we'll still, if they push back, we'll follow their stupid rules. But it's
what cracks me up about it is, these actors in these cases, they seem to think that the only due process to follow is the one that they wrote. No. No. So, that's the hilarity of, doing the work that we do. And it's funny when you start to see your interest align with the people in power, you start to notice some changes in the results of the way these things turn out, which is, ironically, we always say, I feel in my gut that something's wrong. And me being me, I just say, well, yeah, these actors over here, they're the problem, but they're not the only potential solution. We have, of our 4 pillars of government, the 3 branches that we refer to as the government of, our Congress and the executive as well. So there's more than one process. And if you don't like the one they got, write your own. That's exactly what I did.
This is the thing is people just accept what is being done by a corrupt legal profession in collusion with judges. They just accept it, and they're like, okay. I don't accept it. I apply the law and the Constitution and say, this is what the law of the land is. I'm going to give you a quick example. This is the same Supreme Court brief. This one here is printed on 60-pound paper that they require. So that's cardstock. This one's printed on copy paper. You see, what a waste of paper. And the reason that they did that, Kirk, you made the point on this. It started out, they created the rules of procedure. Initially, the first rules came out in 1938. The Federal Rules of Civil Procedure and the Rules for Supreme Court. 1938 is when they first started, and it was to kind of organize the process. And I think they had good intent at that time, but then they changed the rules, to complicate the process, to make it harder for people, so that they create a monopoly that only lawyers can figure out because they've had the training behind it. And so they started complicating the process to establish a monopoly. And then from there, what they've done now is they're creating rules that confound due process, that violate due process, that deny equal access to the courts, are the rules that put in place now to support the corruption in the judiciary and the legal system. And we, the people, are going to go to them and say, we're not okay with this. These rules are crap. The reason they came out with this 60-pound paper was around the 70s, when PCs were becoming more popular, and individuals were able to start printing documents themselves without going to a printer. And they're like, well, we can't have the people seeking justice, so let's throw another roadblock in there and say they have to do it on 60-pound paper, because they won't be able to print that on their home computer.
You know who lobbied for that?
What's that?
That would be the paper mills. The ones who lobbied for that were paper mills, right? Because they stood to benefit from it. So what the bar did was they said, hey, we're going to talk these paper mills into, creating this card stock and marking up the price. And then we're going to make it so that this is now a requirement if you want to do anything in the legal profession. And the paper mill companies went, yeah, sign me up. I'm going to make money, right? So they create this special interest group by doing crap like that.
Okay.
I got a price to print those booklets at a printer, over $3,000 to print them off. That's ridiculous. That in order to find justice, you got to throw out $3,000 to do it. But I'm pretty resourceful. I did it myself.
So here's the thing. Okay, we have to understand that again, that the Constitution, supreme law of the land. Law of the land, right here, Black's Law Dictionary, means due process of law. Okay, so this is the supreme due process of law, right? Okay, and then state constitutions are just the due process of law. Okay, and obviously they're a hierarchy, like in military, you have officers and you have enlisted, and in each set has their own set of ranking, a hierarchy. So a private doesn't come and tell a general, dude, what he's going to do, right? We don't have privates telling lieutenants, first lieutenants and second lieutenants what they're going to do. We don't have privates telling sergeants what they're going to do, or corporals. You know, it's a hierarchy. So this is our form of government as it was ordained and established, right? So here, Article 3, the Judicial Department, judicial power. This is Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish, right? Okay. The judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall, at stated times, receive for their services a compensation, an emolument, right? Which shall not be diminished during their continuance in office. Now, the first thing to understand here is that Congress, from time to time, may ordain and establish these inferior courts, but based on the powers that were delegated and the powers that were not delegated. So you have to read the Constitution in its entirety to understand what powers they do have to create these inferior courts, right? Because we go into Section 2, extent of judicial power, right? Supreme Court, trial, and places of trial. The judicial power shall extend to all cases in law and equity, arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. Okay. The judicial power shall extend to all cases in law and equity. You're muted, John.
That's an interesting point, Kirk, because I want to use that and incorporate that into our brief, because it says all cases of constitutional question, right?
Right, but more specifically is arising under this Constitution, right?
And that's exactly what our case is about the unenforceability of a right of due process. That's what we the people case is about. So. Right. So the law, the Constitution says all cases arising under the Constitution, and they have twisted it in the judiciary and say, well, we can pick and choose what cases we want to hear. No, they
right.
can't. No,
as it is written in the Declaration of Independence, it is a declared act of tyranny that the legislature had taken over our legislature and legislating for us in all cases whatsoever. So, in understanding what this actually means and says right here, okay, the judicial power shall extend to all cases in law and equity arising under this Constitution. Okay?
They can't say no.
So the thing is in law, right? In law. So, what we have here at the 7th Amendment is the I don't know, quite the conundrum. If you don't quite understand what I'm talking about yet, I'll get to that. But trial by jury in civil cases, in suits at common law, right, where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So, where are the common law courts? Because obviously the common law courts are separate from the judicial power extended to all cases in law and equity. That's not common law, right? In law and equity is not the common law, or we wouldn't have the 7th Amendment, right? As it would say, suits at the common law and equity, because there's a limitation here, and it's called admiralty, jurisdiction, and maritime law that is delegated to the federal government. That is for punishing piracies on the high seas, right? That's what it says.
Mm-hmm. Let me expand on that for a second, Kirk, if you don't mind.
Okay. I have more, but go ahead.
Okay. To tag on to what Kirk is just talking about, okay, this is when I started my research into this project, and I stumbled across the word emoluments and its significance. I'm going to use Texas as an example because Texas is actually very clear about this. It says all free men, when they form a social compact, have equal rights, and no man or set of men. Okay, we have an entire branch of government run by a set of men. That is in violation of the Constitution and has been for 230 years. The difference between then and now is back then, like John said, when they first started this, they did have honorable intentions, so we just kind of let it slide. But the more political things became, and the more they started to intrude into our homes and into our lives through their word salad, domestic violence to mean violence in the home instead of violence out on the land. Okay, that's an example of the stuff that we're talking about. But I just wanted to point that out. So anyway, I'm going to go back to see if I can point right at that. I'm trying to watch. Okay, there's Kirk down there. So have at it, brother.
All right, brother. So in reading the law, the Declaration of Independence, okay, when in the course of human events it becomes necessary for one people to dissolve the political bands, right? Political bands, which have connected them with another, and to assume among the powers of the earth. Okay, powers is a capital P there. So powers is an actual thing. The separate and equal station to which the laws of nature and of nature's God entitle them, right? A decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. Okay, well, what's actually happening here? If you've read some of the historical documents that I've shared before, the first one, the Declaration for the Causes and Necessity of Taking Up Arms, July 6, 1775, they talk about that admiralty and vice admiralty jurisdiction, right, being extended beyond their ancient times and rules, right? We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, okay? Certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. Okay, among these unalienable rights, life, liberty, and pursuit of happiness, life, liberty, property, and pursuit of happiness are not the only rights that we have that are unalienable. Okay, for those of you like to say unalienable, it's actually unalienable, which is what they said back in the day. You won't find it like that in Black's Law Dictionary because they don't want you to understand that you can't place a lien upon our rights. Okay, they didn't.
I wanted to go back to your when you first started this off, you were talking about jury trial, right, Kirk?
Well, what I'm actually talking about here is the powers delegated in the judicial branch, right? So those rules that are promulgated, okay, those rules, because of the limitations that we put on Congress, right? Right here, Article 1, Section 8. And then in Article 3, Congress may make these inferior courts, okay? Right? Under what jurisdictions?
In the very beginning, when you first started off, you were talking about jury trial, right? And I wanted to share it because this is a big part of the case that we're going to bring in the Supreme Court. I'm just going to share my screen just for a real quick second. This is does that show up okay? Can you see? I'm just going to go real quick.
Yep, there you go.
This is out of the Federalist Papers, number 83. Alexander Hamilton wrote this one, and he's talking about the strongest argument in the favor, talking about jury trial, that it is a security against corruption. And there's always more time and better opportunity to tamper with the standing body of magistrates than a jury summoned for the occasion. And that's the primary redress that we're seeking, is to restore. And you just read it in the Constitution, that we have a right to a jury trial in all civil matters exceeding $20 under our federal constitutions. And our state constitutions guarantee it. And they wrote this into the constitutions because they knew the same crap that King George was doing to us, and that England was subjecting us to these mock trials because all the judges had been corrupted at that time. And there were a lot of public hangings, that resulted out of these corrupt crown magistrates. And this is the main. At least it get. I mean, you can corrupt juries. You can put up slick arguments and bastardize the law, but at least you got a fighting chance. If you have a jury in there.
Now, the key thing here to understand about what you were just talking about is no fact tried by a jury can be heard in any other court of the United States, right? Because when the people speak, because that's all political power is inherent in the people, right? Okay, we have the right to alter, reform, and abolish anything at any time, because that's the powers not delegated, nor wasn't delegated to the federal government, wasn't delegated to the states either, because that's why it says all political powers inherent in the people, not the government, not the representatives, right?
That's another good point that I'm going to make in this brief, Kirk, is that power is inherent in us, and we don't give a crap about your stupid filing rules. We really don't. You need to recognize that power is inherent in the people. That's a really great point. I'm going to incorporate that as well, Kirk.
So what I'm trying to point out here specifically is the fact that these inferior courts are not to be inside the borders of a state. We are supposed to be living at the common law, right? Anyone who is acting according to Article 1, Section 8, Clause 5, I believe, is in foreign and interstate commerce, right? So on the navigable waters, out on the high seas, right? That's where that admiralty jurisdiction, which is an administrative court, right? Basically like a military tribunal, almost exactly. So those inferior courts created by the federal government are supposed to, they're limited to admiralty jurisdiction or suits in law or equity. But we're supposed to be living at the common law. We're supposed to have common law courts. So when we have a dispute between two people, and Erie Railroad versus Tompkins, okay, that is a deep case. I've read it a couple times, and it's hard to comprehend. The gist of it is somebody got hit by a train in the city, and they were trying to figure out where the jurisdiction is. Where's the jurisdiction to sue these people? Okay, so that's why it was Erie Railroad versus Tompkins, and essentially what it is it breaks down all of the jurisdictions and certain jurisdictions like what we're talking about right here. So those rules of procedure actually don't apply to us, right? Because we're not in an admiralty jurisdiction court.
Yeah, and I was reading, so I picked this up, 1936 book. It's Jurisdiction of the Supreme Court of the United States. It's kind of fragile. The pages are a little tender, but it used to be back in 1936 and prior to that if there was any question about whether they should take a case, they always took it in defense of the Constitution. And now It's the opposite. You know, they have so many cases. Like they're taking a break coming up in June to October. You know, when there are important matters facing this country, do we really need 3 months off? Like, what are we paying these judges for so they can take an entire summer off of work? You know, their clerks do the work for them. I think it's just, I mean, to be honest, I just think it's a waste of taxpayer dollars that these guys have so much time off.
Well, I don't know about y'all, but I work 379 days a year, so I don't know where the hell they're getting their work schedule from. So, I mean, just saying.
What makes it so special, you know? What makes it so special that they can take that time off when there's a case that like I'm working on to preserve due process in the state of Tennessee, and the case that we're going to file, you know? Like, you would think they would reconvene for something like that they would be assholes over elbows trying to get back in there and hear this case. And yeah, they go on break.
So one of the deals there in Erie Railroad versus Tompkins is that for suits to be proper, must be in like kind, right? So suits between man and man must be heard at the common law, because that's where we live. We live at the common law. That part here where we're talking about in the Declaration of Independence, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Okay. Decent respect to the opinions of mankind requires that they should declare the causes which impel them. Anyway, I'm trying to remember which one it was here. Anyway, rights impose a duty, right? So when your fellow man has a right, which is equal to yours, you have a duty to respect that right and not trespass the law and deprive another man of their rights without due process of law. So this is another thing, bringing things into being. That there's that legal maxim out there. I just love this one. A repugnant act cannot be brought into being. So bringing up the Erie Railroad versus Tompkins, where we have suits between a man and a man, because you have to be in like kind. So those of you out there will understand this real quick that have ever received a traffic ticket or any kind of a misdemeanor or even a felony. It's the state of versus you. That is an unlawful jurisdiction. That jurisdiction has no standing in law. It is state of to the law because the government itself doesn't exist. It's a figment of the imagination, like it says here. And even Idaho Code Title 74, Ethics in Government, Section 201. The people of the state of Idaho, in creating the instruments of government that serve them, do not yield their sovereignty to the agencies so created, right? So what that essentially means is, yes, we allow you to create agencies for what? Well, it's listed in the Constitution for what? And your limitations are limited. You're limited by what by the consent of the governed, right? What powers you have. And you cannot create an inferior court using your bills of attainder, your unlawfully created inferior court, and then promulgate rules regarding those statutes and those that unlawfully created jurisdiction. So
this is the big turning point that happened in this country is the state legislators, many of whom are bar members, and in collusion with the bar and the judiciary, create these laws for the single purpose of enriching the legal profession. You know,
I like how you put that before. They create new product lines for themselves.
Yeah, that's exactly what they're doing, and nobody's challenging it. Nobody's challenging it, but we are. You know?
I was going to say bullshit. I think I would qualify as a challenge.
Yeah, I would say so. But you know, no attorney would ever buck the system and do what we're doing. No way.
Oh yeah, you can't even walk into a courtroom and breathe that word. You walk in a courtroom and breathe that word, oh, they will bounce you out on your ass if you walk in a court and try to do what I'm doing. Yeah, they scurry out of there like freaking, you know, like I said, like cockroaches, man. It's just like, yeah, you know you're breaking the law, you prick.
Right.
Yeah, when your long train of abuses and usurpations, yeah, I see your ass. Yeah. So it's my Robert De Niro moment. Yeah.
All right, I'm having some issues here. Hold on.
Ruh-roh. He broke it.
No, just an Ethernet connection here. I don't think it's functioning correctly. It might be time for a new cable.
Uh-oh.
Well, while you're playing with that, I mentioned this earlier, and if you guys didn't pick up the show last week, I started drafting an extraordinary writ, and basically we're just going to go into the Supreme Court with this writ, and I'm going to file this as myself, actually against the clerk's office, the Supreme Court clerk's office, and do a writ of mandamus and ask the Supreme Court to adhere to the Constitution, enforce the Constitution, enforce our unalienable right to be heard. And I think it's going to be kind of fun. It'll probably piss them off a little bit, but I've pretty much been pissing them off for the last couple of years, so I'm not too worried about pissing them off a little bit more.
Well, you know, I'm pretty sure the closer we get to filing this, and once we get it filed, there's going to be a lot of people pissed off at us because we're going to take away their powers. All of this, you know, I mean, it's at the point where we just need another declaration.
Yeah, and I
hereby declare this stuff unconstitutional. It's unlawful.
Hey, I already said there ain't nothing wrong with the one we got. This is the one you're going to follow, numbnuts. Not 728 pages of guidance documents. Throw that shit out there in the street.
Here's the thing that we have proven already now. The fact that we have hearings, and even though they're mock trials, the fact that we have them means that they have to provide the appearance of due process. They have to. Otherwise, you know, they could just come out and take your kids without a hearing. Well, they do that too now.
I was going to say, they're doing that shit anyway now.
Yeah, but they could come out and take your kids, take your property, and not even bother with the trial. Not even have the mock trial. But they have it. And they have the mock trial because they have to. They have to present the appearance of due process. And so what we're doing is we're saying, well, here's what due process is, and we back them up against the wall. And I've already proven that it's possible, even when you have corrupt attorneys from a very powerful law firm colluding with corrupt judges from powerful families and powerful positions. And you can still force their back against the wall and say, you got to rule according to the law. And that's what we're going to do. That's what we're going to do as we, the people, is we're going to go to the Supreme Court and we're going to back them up against the law and say, here's the law. And, you know, at their level, I believe that it's not like a trial court where they can do whatever the hell they want, because what we file, when it's docketed, it's going to be there forever. You know, it's going to be in the record for everybody to look at. And I don't think that they want to evidence that we are under a tyrannical government and that we are subjects of despotism. I don't think that they will do that publicly. And so I think that we are in a very peaceful way using the the mechanisms that our founding fathers put in place for us. We're gonna change this monster, and we're gonna turn this thing around and restore due process, or at least mitigate it a little bit, and start the process of this, and then we'll go back in. Well,
actually, it's funny you bring that up, John, because the stuff you're talking about, I've already done through the Library of Congress, right? So, for example, when I file my reports, the most recent package being that 14 pounds of paper that just got dropped off on the Rayburn House building over there in Washington, D.C., that went right to the Library of Congress. That is there forever, right? That is that paperwork is never going away. So
that's the beauty of this team is, we're hitting them with on the legislative side. We're hitting them. We're hitting them in the highest court. We're doing everything that we can to try to restore the Republican principles of this country. So honestly, I think they know that it has gotten out of hand. I think they do. From the judges that we see it seems like on a monthly basis, getting arrested. The media is starting to talk about it now and publishing this stuff. I think they recognize, and what we're doing here is we're giving them an easy way out. We're saying,
I mean, I wrote them a process that's so easy. As legal scholars can wrap their heads right around it. The problem with it is they don't want the bad actor attorneys don't want them using it, because then literally it takes away all those new product lines you've been talking about, right? So, now they're going to go back to figuring out, oh crap, that means I actually have to go to work now. Oh, no, yeah. So, it's interesting when we talk about how actually education is not actually worth the money you spend on it. And, it's bizarre that, myself and John and, most of my family, we're all college educated. And of the hilariousness of this whole thing is between the two PhDs in my family, my brother and my stepmother, the only one who's actually been able to actually ever do anything is the guy with just the regular little 4-year, college degree. So, when it comes right down to what they want to stand there and talk about the shit that I've actually spent my career doing, right? It's just like, come on, guys. Yeah, I write these processes. I mean, that's what I've been doing my entire career, and they're going to sit in somewhere in a classroom and read about it. Well, that's not going to do any good. Why are you spending money learning how to, reading about what I did instead of just getting your happy ass up and going out there and doing something? And then you like I said, I don't know. That's just me. I'm a little too mechanical for most people.
This is an interesting point about the legal profession. So in this country, there's 3 professions essentially: medical profession, the accounting profession, and the legal profession. Doctors very obviously provide a service to society, and they're self-regulated, and it requires a high level of education to become a doctor. For accountants, our entire economy depends upon CPAs giving opinion on the financial statements of companies that are traded on the stock exchanges. And we go in there and CPAs, I'm a CPA, CPAs go in and audit the financial statements of these publicly traded companies, and we say, yeah, these financial statements are materially properly stated. and in accordance with generally accepted accounting principles. The legal profession, they don't provide a service to society anymore. They provide a great disservice to society. And if you take a look at any profession or any skilled labor, you know, engineers build bridges, they build buildings. You know, accountants, you know, we keep track of the numbers. We make sure that the company is profitable. You know, a plumber, you know, he's out there laying pipe, making sure that water and waste gets to and from where it's supposed to go. Attorneys just provide a disservice to society by creating unnecessary litigation and by confounding the process. They're like a leech on society, and then colluding with the legislatures now so that they can create these new fictions of law to sue businesses under, to further incarcerate or fine people. The legal profession is the biggest drain on this country. It's the biggest scam that I could never think up a better scam than these guys have come up with. And it permeates every part of our society, these lawyers and judges and collusion.
Well, you know, you got to remember too, we talk about the things that we do in life, we just do it by repetition. You know, one of the things that people do by repetition, especially if you're working in a service industry of any kind, okay, you're working transactions with money, right? And I don't care if you're selling cars, televisions, haircuts, it doesn't matter what you're selling. There's a transaction process that somebody wrote that you're following, whether you wrote your own or whether you're using somebody else's system, okay? So when we talk about where those systems come from, these are the systems that John, myself, and you know, other people like us, that we've created these systems, you know, over the course of the years. So when we talk about, you know, back when point of sale systems were first being designed, we actually had to draw these matrices, you know, these different models, both 2-dimensional and 3-dimensional versions of what a transaction is going to look like. So when we took and we picked up this thing and we said, okay, we want to run this thing across that barcode reader, and every one of these that goes across that barcode reader has to go through the exact same process so we can maintain the truth in the record, right? The truth in the record was an inventory record. So that when we talk about the truth in the record in court, okay, by not following the process of law as, you know, as it is written, there's no truth in the record. The numbers are all wrong. The case precedent is all skewed. The decisions are wrong. Judges are even coming out and admitting, I mean, good ones, the real ones out there, who are like, you know what? Yeah, Houston, we got a problem here. So, you know, even they're already coming out in droves and they're saying, you know what? Yeah, you know, even when I'm writing half of these decisions, I'm writing stuff that I know to be wrong or faulty because just the way the case was presented. So when we talk about things like case steering tactics, okay, you have, you know, actor A presenting this magnificent, eloquent theme, and then over here actor B says, which is usually your defense counsel, does nothing for you. The court can't, remember, because like Kirk says, you know, raise your hand, right? Well, if that actor doesn't raise his hand and defend you, guess what you're stuck with? That magnificent, eloquent theme, right, that this other actor wrote, and now you're committed to that. The judge, I mean, you know, most of them do see this. They don't like it, but there's nothing they can do. You know, it's like that there's a downside of them not being able to practice law from the bench, and that is they can't get up, walk down there, grab your attorney and kick him in his ass and say, hey, stupid, do something, right? So that's where we talk about, you know, for every, you know, action, there's an equal and opposite reaction, you know, cause and effect. Well, because there's no, there's this bad effect because there's no cause from the bench, or anybody saying, hey, stupid, you got to follow the process and defend your client. You took the guy's or the girl's money. You got to do something for them. Here's the process. You got to follow this.
Let me give you a really good example of the legal scam and lawyers and judges and legislators conspiring together. This is a really good example. So I pay a lot of attention to California because California is one of the worst for this kind of crap. They enacted a few years back a 5-hour lunch break rule. That if the employee isn't provided a lunch break within 5 hours of their shift, then they get paid an extra hour of time. And companies in California have to pay this. And then the lawyers go around and they place flyers on the cars in the parking lots of these businesses. And they say, hey, if you're not getting your break in 5 hours, we can sue the company and we can get you a lot of money. Now think about this. Do you really think that the people of California were confident their legislators saying, I'm hungry, I need a break in 5 hours? Do you really think the people of California were doing that? Nah, I'll tell you how it happened. Is some lawyer got together with his lawyer buddy in the state legislature and said, how are we going to make more money here, Bob? And he's like, hey, I got a good idea. Let's enact this law that employees have to have a break in 5 hours. And then we'll go out and place flyers on cars, and then we'll sue the attorneys. And, the state will fine them too, so that the state gets some more money out of these businesses too, and we can extort from them under color of law. And then these guys probably go do a line of Coke and do a shot of whiskey and pat themselves on the back, saying, we got another scam here, guys.
Yep.
We got a new product line we're getting ready to launch. And then the governor signed this crap. So the executive branch is in on this crap too. This whole legal scam is it's ridiculous how it is affecting our society. And those laws that are adverse to business out in California is why there is such a high unemployment rate and why there is such a huge problem in California. So if the rest of the country wants to know what's going to happen if we don't start to put checks on this corruption in the legal profession in collusion with the legislatures and the judiciary, look at California. That's what's going to happen to the rest of this country if we don't do something about it. These guys drive me nuts with this stuff.
Well, it's by design, a big scheme. And it's, been around for a long time, long before, right back to the Declaration of Independence there. The political bans, that's what they're talking about. The separation, we separated because of those political, issues. We don't want your admiralty jurisdiction or your vice admiralty jurisdiction. We have rights, and if somebody violates that rights, we have a process over here called the common law, and the rules of the common law apply. And it's real simple. I don't understand why we have to have all this stuff. Well, I do understand why. I should say, not that I understand, but I comprehend why it is the way it is. Mm-hmm.
Well,
it's
I'm going to answer Mary Jane's question real quick.
It's a scam to make money.
Right. I'm going to answer Mary Jane's question real quick here on this. We were discussing this earlier in a private message. She writes, Chris, would you mind briefly covering attorney misconduct through delayed entry of orders and squeezing in their own verbiage in the order, like we were talking about, how they use the word salad. So basically what we were talking about, you come to an agreement, okay? And there is this document called a memorandum of understanding that was created during the hearing, okay? these things were presented. The judge said what the judge said and says, now go write me an order and I'll sign it. Here's what they do. This actually happened. This was Altenhofen's biggest problem. Not only did they delay the order for 5 months and drew him 5 months behind and turned that into a criminal offense, right? Which the federal judge said they couldn't do, so they tossed it out. But they take this, they purposefully delay, because it only takes about 20 minutes to write an order when you have the memorandum of understanding and it's fresh in your mind. It takes 20 minutes to put it on a piece of paper. I've done it. So because they delay this stuff, they want the judge to, number one, not remember what they said. So when they come in, these attorneys, they come in and they change the verbiage, right? They'll insert the word not somewhere where it doesn't belong. So that changes the entire context of the sentence. And just little things like that they'll do. So what ends up happening is the general order itself does not read the way it was intended to read, right? So this is the stuff that we were talking about earlier.
I'll give you a perfect example of that, Chris. Happened in my case, and it's actually a big part of my federal lawsuit. This is exactly one of the scams that they run, and you laid it out perfectly. They wait a period of time, and here's a perfect example. I turned to my judge during my hearing. I flip-flopped this guy. He had been violating my rights, bullying me and harassing me for 2 years. And I turned him. He finally let me talk. Pretty reasonable. I laid out the facts. I supported it with evidence, and I turned him. And so we got down to the end of the hearing, and he said, you know what? I'm just going to declare the parties divorced today. I'm going to reserve all other matters. I'm just declaring them divorced, nothing else. And he looked at opposing counsel and he said, if you would like to write an order for that, reserving all other matters for the court, I'll go ahead and sign that. First of all, a judge should never have to tell an attorney to reserve matters for the court, because all matters should be decided by the court. So in my case, it's pretty obvious that the attorneys had to leave the court to write whatever order they felt like writing, which they did all along throughout the case. So the next day, and Chris, this is gonna really hit it home for you. The very next day, they turned in an order, and it said, divorce decree, all other matters reserved. That was the title of it. Divorce decree, all other matters reserved. Then 30 days later, they tendered another order for the judge to sign and awarded attorney fees against me. And the judge signed it. Now what I did in my case, I brought in the transcripts and I said, you specifically said to reserve all matters for the court, and they tendered this other order, and I did a motion to alter. So that's how you fight that. When they do that, is you come back and you do a motion to alter. And the motion to alter typically has to be pretty fast according to their bullshit rules. But you got to get that in there like 14 days, and you do a motion to alter. The first thing that I did was an objection. So most trial court rules say if there's a proposed order and you object to it, you can file an objection to the proposed order saying it doesn't. So I did that. And of course, the idiot never reads anything that I write. And so he signed the order anyway. And then when I did the motion to alter, he's like, well, I already signed it. I'm not going to change it. And so what that judge did then was he conspired to extort under color of law, is what he did in that case. And that was a criminal action by the judge in my case, which I brought suit for. But that's a perfect example, Chris, of how the next day they turned in the order, divorce decree, all other matters reserved, and then they wait 30 days and went against the express instructions of the judge and extorted me under color of law. And then they went back and got the judge to conspire with them to extort under color of law. That stuff is crazy.
Which is one of the reasons why when I hit you with this legal maxim, you loved it so much. He who under the cloak of the law acts unjustly should bear double punishment, right? And I've been posting that like everywhere, and there's a bunch of them. Person of guilty is guilty of barratry who sells justice for money. A judge who exceeds his office or jurisdiction is not to be obeyed. I mean, these are maxims of law, right? These are core concepts of practice. In other words, if you went to law school and you passed, you should know this shit, right? So basically, like, that's like, you know, fiduciaries like John and myself, when we're sitting there, you know, we're going over these transactions and we're doing these audits, okay? And that's like us not knowing the principles of mathematics or algebra or trigonometry or you know, how the hell could you be an auditor and not understand the core concepts of mathematics, depending on what you're working on, right?
Yeah,
so
I want to hit Margaret. Chris was asking, you know, the transcripts aren't available in 14 days. So Margaret, here's how this process works, or how it's supposed to work, is opposing counsel is going to tender a proposed order to the court, which is typically full of shit the court never said. And they will provide you notice of that order. As soon as it should be the same day that it's tendered to the court, you should get a copy of it. So the first step is you write an objection to the proposed order, and you get that file stamped and get it into the record. And you just detail out and say, the judge never said this. And the transcripts will show that the judge never said this. You don't have the transcripts yet, but you assert that the transcripts will show the judge never ruled that. Then the idiot judge will typically sign these orders because, one, they're not paying attention, like my judge wasn't paying attention, which is gross negligence, by the way, also. And they'll sign the stupid order. So then you go in with a motion to alter, and you can't, you know, you won't have the transcripts in 14 days. But you still file that motion to alter, and you set the hearing date for that motion to alter far enough out that you have to file it within 14 days, but you can set the hearing date out far enough that you can get the transcripts, you know, and get them into the record. For myself, I don't walk into a courtroom without my own hired court reporter. I always bring my own with me. I have a court reporter that's a certified court reporter. I don't go in a courtroom without one. So if you don't have money, you know, a lot of people can't afford, you know, to bring a court reporter in with them. You know, you can get it, you know, it depends on the state. Some states are like $150 for transcripts. Most people can afford that. Chris, you're muted.
Just another way to deny us due process and effectively defend our rights, because first they're claiming that they have the authority to record and transcribe, and you have to pay for that. We've been over this one before. Here, let's go back to the Idaho Constitution here. Before we get into that, Kirk, we're getting a bunch of people asking us when we're going to be, when's an expected file date on the We the People case. Remember, this is projected. Is, you know, this is not one of those things you can just, you know, kind of like and throw it into the Supreme Court. This takes time. So I'm going to turn that over to the boss man right down here, who's giving us the, you know, taking the charge on getting that rascal filed. So take it away, John.
Somebody said that the transcripts can be altered, and I've heard of that. I've never seen it myself, but I don't put anything past these guys. Get the audio, request the audio.
They've done it in my case.
If you know, get the audio. If you believe that the transcripts do not reflect what actually happened, and I didn't know it at the time because of my learning through this process. But what I would do now is go into federal court and say this order does not reflect. And
Right.
And I have been extorted. I've had my right of due process violated. These guys have conspired against me, and I would go in and do a TRO in federal court or habeas corpus.
Okay. This is Article 1, Section 18 of the Idaho Constitution. You'll find this very similar wording in all state constitutions. Justice to be freely and speedily administered. Courts of justice shall be open to every person. And open to every person, imagine that. And a speedy remedy afforded for every injury of person, property, or character. And right and justice shall be administered without sale, denial, delay, or prejudice. So, filing fees are unlawful. Selling you justice, selling you the access to the court, that would be an emoluments violation. That is an unjust enrichment. You folks are already being paid if you're there. If nobody were to show up to court, you'd still get paid, right? So that's your emolument, technically speaking. So an emoluments violation would be charging a fee for someone to file anything, a fee to get a copy of the transcripts, right? Because you already paid for that.
Well, in a civil matter, you should pay for it. But in a criminal matter, if you've been thrown in jail, right?
No. It says without sale, denial, or delay. That's what it says.
Well, I hear you on that, but that's what the informa pauperis is for.
No. This is a right. This is a right.
I get it.
Deny informa pauperis, Chris, just so you know, even when they.
I was just getting to that, but I couldn't finish.
Informa pauperis basically is
deny intentionally anyway.
I'm poor and I can't afford this. Well, yeah, they drive people into poverty because of, right back to what John was just talking about, you know. This is all a scheme and a scam to basically assert this
right?
admiralty jurisdiction, bills of attainder. You've been attained to pay this bill. And using charging instruments to charge us in the admiralty inferior courts that are unlawful courts. I mean, that's plain and simple.
Well, here's where I was going with this. You know, I actually witnessed an attorney in a courtroom tell a guy because he had a car, he could afford. He was supposed to be paying all these fees and shit. So he didn't have a job. For whatever the reason was, I didn't go into that. The point is, you know, yeah, he did have a car. He was out putting in applications and, you know, trying to get work. But, you know, he said, you know, hey, at least, you know, if you don't want to grant the informa pauperis, you know, at least, you know, grant me an extension on paying the fee until I can secure employment. That's all the guy asked for. Nothing unreasonable. It's not like the state's going to die because the guy, you know, was going to be a couple of months till he got a paycheck, right? Nope. Nope. Not only did they deny his request, they told him they were going to start charging him, you know, extra fines and late charges and it's all kinds of crazy bullshit. That's the stuff that that they can't do. That's the stuff that you're talking about, Kirk, is you know, not just the actual fee itself, but it's all the crap that they pile on top of it. And we're, you know, what's their standing to even voice an opinion about you in your professional career? And the answer is they don't have any. So again, when I talk about, you know, why the hell do we have an entire branch of government run by a set of men that violates the Constitution itself, which is, you can clearly see that they have an agenda. You know, I mean, come on, guys, talk about self-evident. So that's my 2 cents.
Chris, Kirk, and anyone else on the call.
I want to remind people out there that this is the call-in show. So if you got a question for us, hit up the number there, 1408. Okay, now you make me have to read Oh, I should know it by heart. Actually, I have it written down here. 1-408-638-0968. Okay, you dial that number, and then it's going to ask you to put in the event ID or something like that. 376-657-800, and then push the pound key and use the audio on your phone. If you have Zoom, that's fine. Try and connect without video. So when you log into Zoom, just use the 376-657-800, and you can join a meeting. Just make sure that you don't join a meeting with your video, because this is all preset. And so when somebody joins with their video, it screws everything all up, and then Ted has to scramble, or me when I'm doing it. So
that's interesting. Margaret, Chris is hearing impaired. I'm hearing impaired as well, and that was another thing that they would love using against me, was my hearing impairment. And so they'd have a little quiet dialogue, and I'm like, what the hell are they saying over there now? And I couldn't hear. And I would request a hearing assist device, but the hearing assist device wouldn't be operable while they're having some dialogue going on over there. And but that's another advantage of the transcript.
Are you talking about ex parte communications?
Yeah, it's like, deaf guy over there can't hear shit, so let's screw him right now. These guys, they want, to take advantage of the hearing impaired veteran. Like, what kind of crap is that?
They just don't care. They don't care who you are.
Anything they can do to make a buck.
They even attack their own. They're ruthless.
I got a question.
What's up, Darren?
Hey, how's it going, guys? In all your infinite wisdom and research, has anyone ever ran across a law that says you have to have a job?
Nope.
Okay.
In fact, you have the right to contract your labor if you see fit.
Has anyone ever ran across any rulings that say the court has authority to make you get a job?
The only thing I've shown is what the court can't do. I've never seen a case that the court can make you go do anything, right?
I've just wondered that's I mean, I have an order that says I have to seek employment, and I also have a finding of contempt
through the appeals process.
Who has standing in law to grant to seek that relief?
Nobody, but that's what I'm trying to say. I've looked and I couldn't find anywhere where you have to have a job. And
these court administrators don't have the authority to make orders. That's again, back to our fundamental principles of law here. Can only be granted relief based on your right to a cause of action and your demand for relief, right? Mm-hmm. And these judges, whatever, they're supposed to be the disinterested third party. They are not a party to the case, right?
Well, they can't be disinterested if they're drawing funds from it.
Well, that's what I was going to get at is, a question to ask out there is, do you have an equitable interest in the case, in the matter before the court? Because if you do have an equitable interest in the case, then you're biased, and you can't preside over this case, because that would be not acting in good behavior.
I just wondered. I was getting ready to file habeas corpus tomorrow and put my stuff together, and I was looking across the contempt finding that they did on me and he specifically says they find me in contempt for failing to find a job. So, I just think that's pretty good grounds for getting them to reverse the contempt issue. When I take it to federal court.
Good. I think a writ of habeas corpus is, by design, and what I've read there in Kirk's Law Corner, my group, the private group, I've got a document and a PDF in there about the history of the writ of habeas corpus and what it's really about. If you're deprived of any of your rights at any time, you have the right to a writ of habeas corpus and demand right now, bring the body and bring your papers. You better have lawful authority to do what you're doing.
Well, the key word is any.
Here's the only thing that the book says about employment that I've ever run across. Now, like I said, I could be wrong. I could have just missed it. But the only thing I've seen is a maxim of law that states, let everyone employ himself in what he knows. Right?
Yeah, employ himself.
Yeah.
Yeah, but that employee is a different meaning.
I get it.
The same employee as a job.
I get it. But that's, like I said, you asked. I'm answering the question. So,
well, yeah, it says employ himself.
Good. Yeah.
Not go get employed by an employer.
That's my point.
Yeah.
Right?
Yeah.
You know,
I'm just reiterating what you made there.
To hear the attorneys, you know, remember the domestic violence word salad? I could see an attorney taking that word, using that and twisting that in some kind of word salad to say, oh, I can tell you to go get employment. No, wrong definition of employ. You know,
well, the reason I asked the question, Chris, is along the lines of what you said, and that a judge that's issuing orders that are unconstitutional is not to be obeyed.
Correct.
It's not that they're unconstitutional; they're unlawful.
Right.
Well,
they don't have that lawful
and an illegal. What's the difference between an unlawful and an illegal? Right.
Well, unlawful meaning has no standing in law.
Right.
Right.
So these administrative tribunals, because they have no standing in law, that makes their orders unlawful. So what the hell are these assholes doing enforcing unlawful orders?
Oh, we got a call. Let's see who we got here. All right, last 48190. Welcome to Kirk's Law Corner Live Wednesday night call-in show. You have a question for us? And who are we talking to? Oh, wait.
Hello. Who are we talking to, please?
Is this Chris?
Yes, it is.
Uh-oh. Hang on. I got to turn the thing down. This is Lee.
Hey, Lee. What's happening? Did you get my text message?
I made it. I'm up.
Did you get my text message?
What's the name?
I did.
Okay.
I was trying to send you guys I want to get on make a comment, and I don't know how to do that. I'm talking to her, but I don't know how to do that. Anyhow, love what you guys are doing, and I got to talk to you more, Chris, probably next couple of days. I hope you're handy, because I want to help you guys out. Because you were talking about paper.
Yeah, oh, remember? God, boy. I burned up another box. I burnt one today.
I don't doubt it.
Yeah.
But, I see the trilogy here, and it sort of reminds me of something, and it's not blasphemous. It's like the Father, Son, and the Holy Spirit. I don't know who's who. Because that's how it works.
Who's your daddy?
I say, oh, Father.
But love what you guys are doing. John Gentry, I sent you an email about 4 months ago. You responded, but I didn't know if I'm on class action lawsuit. P. Migliacci is the Facebook name, I think is what they call it. Don't know. So
I tell you, I get a lot of emails.
I'm sure you do.
I get
sorry.
a lot of messages. Do not hesitate to nag me. Follow up. I try to respond to everything, but I miss a couple here and there. So, if you guys, I actually prefer not to be messaged in Messenger because it's blowing up my phone.
Yeah.
I was trying. Oh, I'm sorry. Go ahead.
But yeah, if I don't get back to you, follow up with me, man. I'm just really busy, and I try to help everyone I can. But we all got a lot going on.
Basically, what I was trying to do is I was trying to make sure you had me on your class action. That's all I was trying to do, and I got people over here. Chris knows I've corresponded with him. I had a couple people correspond with him. Kirk, I spent time in Hayden, Idaho.
Yeah.
6-month hiatus from work. George Gordon was in, what the hell was that, Boise. That's a long time ago. I don't know if that's before your time or not, but that's how long I've been involved in this. Been to jail 9 times. Never hurt nobody. Just believing in what I believe. And God bless you for what you're doing, all you guys. You don't get it. You just really, you're bringing a ray of hope I've been waiting for 40 years. 40 years. John Gentry, you're a Marine. I told Chris the other day, I know more damn Marines you can shake your stick at. And every one of these guys are saying there's something wrong, that they got nowhere to go.
Yeah.
There's the light. The light's there. So I just, you know, if you get add-ons, in New Jersey, it's probably for me, because I've known some damn good men in the Marines. And I appreciate what you're doing. I'm not going to keep you. I'll be talking to you, Chris, and make sure you talk to Kirk about what I said to you, all right? If you would.
I will be doing that,
right?
sir. Not a
all
problem.
Right,
we'll speak to you tomorrow.
All right, thank you very much.
Okay, buddy.
Have
All right, thanks, sir.
Anytime.
God bless you guys. God bless
God
you.
bless.
God
Much love.
Bye, buddy.
All right, bye.
So you out there talking to other people about me, huh? What's going on there, Chris?
Well, you know, hey, we get the calls, man. You know, we're like the, the Three Musketeers, and you know, we've got multiple nicknames depending on what state we're in. You know, I think attorneys general call us more like the Three Stooges. You know, so hey Mo,
Oh, yeah.
you know.
I, I get so many calls, and I'm like, okay, refresh me what this one's about. You know, because it's just, you know, they
Yes.
and they like think, you know, they think you know your case, but these cases all run together, you know, because it's the same crap they do, you know, from one state to the next. They got the same game plan, you know, and so I'm like, okay, refresh me. What was your? It's hard to keep up.
Right.
You know, it is hard. I mean, especially now, you know, I've gone back to work full time. You guys work full time. I don't have the time available to pay attention to my phone all day. You know, I'm working around machinery and loud noises. I don't even hear my phone. Nothing. I'm lucky if I get to look at it at lunchtime. Sometimes, like when I go to smoke break or something, I'll check it real quick. But I mean, before that, even then, was hard to keep up with messages. I mean, I don't know, 212 now friend requests. And you know, this number has grown over time, right, Chris? And I'm continually adding friends, but I vet each and every one of you that send me a friend request. I go look at your profile. I go look at the kinds of things that you post. When you joined, if you just joined, you know, January of 2018, and you've got one picture, it's going to be hard for me to accept a friend request from you. And then, you know, messages, and it's just, it's seriously a lot. And I understand there's a lot of people out there that need help. This is what we're doing to help. Watch our shows. Wednesday nights is the call-in show. If you've got a question, even sometimes on Mondays, we watch the feed there when I can, like tonight, I just barely got my laptop up and running over here. I had to reboot it 2 different times, and finally it's still giving me a hard time, but probably the weather. But, you know, you got questions, come on here. And I was just about to let that person in, whoever just chimed in. Go ahead and call back if you want to call back. We'll get you in here. So this is what we're doing to help the people. You know, we educate. Go back and watch some of our other shows. You know, we're going to start doing one of these days short little videos on how to do this and how to do that, and how to do this, how to write a motion, how to write an affidavit. the simple basic things. Linda S. Olson Peppers. I swear I have accepted your friend request.
She's a good person. You should, definitely. I see her post.
Yeah, and that's another thing too. Is I watch who comes on here and what kind of stuff you're saying. I cannot keep up. I swear, I'll accept like 3 friend requests, and within the next 24 hours, I'll have 6 more. It's just a never-ending battle.
Yeah, and it's like 1 out of every 10 is a real profile, which takes us forever to get through them. I get so many of those, dating website shits. I try to get, filter all that crap out as best I can. It's just, I end up missing how many friend requests because I'm trying to,
I'm going to start another. I find people will ask me some questions. I'm like, well, you need to file this.
Hold on a minute, John's talking.
Yep. So I get a lot of conversations, and because the cases are, they screw people over the same way. I end up going and sending like the same document 20 times to different people. And so I'm going to start a new Facebook page that's going to be a legal resource page. And I'm just going to load up. I have thousands of pages of memorandums of law, motions, petitions for contempt, emergency hearings, TROs. I've got like literally thousands of pages that I've written over the last 4 years or so. So I'm going to upload everything to this new Facebook page. And I'm going to put it on the We the People website too, as a resource on there that people can grab what they want.
We got a bunch of them. Kirk's Law Corner. You got a page for your stuff too, Kirk.
I have a group. Groups are where you can post, upload stuff. Page you can't upload anything. No PDFs, no nothing. I have all sorts of documents in Kirk's Law Corner, the private group. Yeah. And I'm very picky of who I allow in there. Mm-hmm. So I'll just reiterate this. It is about law. Okay. Not, we're way beyond understanding that there's corruption. I don't need any memes. No, it's just strictly the law. Okay. Mm-hmm. How to do this, how to do that. Here's the law on this. Here's the law on that. I'm very strict with that, and I don't approve. Everything has to be approved. So it's in the about section for the group, and originally the reason why I started it was to do my own research and put stuff in there. So when I wanted to go write something, oh yeah, that's over here, and I could go in there, and there wouldn't be a bunch of BS in between that clogs it all up. So that's what Kirk's Law Corner, the private group, is about, is sharing the law. Not videos, not memes, not how things were going for you today. Strictly the law and dealing with the law and filing paperwork. So anyway, there is a ton of PDFs in there. And one that, John, that I was telling you about the other night, that's probably been a week, almost 2 weeks ago now. You asked me about if this was a common law writ and how we can put this through as a common law writ. Now, I have a very large PDF in there about the common law. So I need to spend some time reading it because it's huge. It's one of those ones that sometimes I just peruse the internet and just type in weird stuff and there's a PDF on that. There's a PDF on that, and I'll download it. And some of the shorter ones I'm able to read real quick and comprehend them. Others that are 1,000 to 1,600 pages. Well, it's going to take a little bit longer to just read and comprehend real quick. But that's one that I need to sit down and read, and then we'll discuss that someday. But back to that question that was asked earlier about, and I'm going to get to the caller here in just a second. This is an 8 to 11 month plan on this We the People versus the 50 United States. So this isn't something that's just going to be happening overnight. We have to build this up. We have to bring the people together. We have to get organized. More research and more stuff to put in there.
Yeah, we still, we need to go identify district court rules that are unconstitutional. We need to go through the state statute. It takes a lot of time to do that work. Getting the people on board is what we need right now. We need the numbers, and that's where we need people's help. Is getting the word out so that when we go to the Supreme Court, there's 250,000 or 500,000 of us demanding reform. And I think that's what's going to drive it home for them is the sheer number of us. Picked up 10,000 in a month. I'm quite confident that we're going to, in a year, we're going to have 250,000 people demanding reform.
Thank you, Michael Paul. He just said he had to go. He's sick and tired of the BS, we're all sick and tired of it. And that's who we want. We want the people that are sick and tired of the corruption, sick and tired of having our rights being deprived. And again, this is not just family law. If you think this is about just family law, then you haven't seen the abuse in other areas, the EPA, BLM, Bureau of Land Management. I need to get Eric Parker on here sometime. I don't know if he can fully talk about what happened there in Pahrump, Nevada, and over in Oregon at the wildlife refuge. But those guys spent almost 2 years in prison waiting to go to trial.
Another point that I wanted to make about We the People, and that we planned this from the launch date about 12 months out. So we're about 10 months out now from filing this. This corruption has happened for a 30 to 50 year period. And we are going to attack it within a 1 year period. And with the litigation and going back and forth, and because the Supreme Court takes their little summer break and they don't work June to October, and we pay them for that anyway. Because of those breaks and everything, it's going to be another year, before we get in there. But we're going to be attacking this problem, and I believe that we're going to fix this problem in 2 years. Something that's been happening for 30 to 50 years. So I think a 2 year timeline is pretty reasonable. And, the wheels of justice in this country is another problem of how they create this process to extort money from people under corporate law, to go through all of this vexation, litigation, and all this crap. So that's another problem that we're dealing with is the slow wheels of so-called justice in this country, which is actually properly termed the slow wheels of injustice. But that's why it's taking so long. And I think it's a very short time frame, considering the magnitude of work to print these things off and serve 50 governors and 50 attorney generals and coordinate all of getting names for 250,000 people. It's an enormous amount of work, because you just give me your email address. We have to go out and then get your legal name, your address, your email address, your phone number. And then we have to take that information, and I'm going to try to build it into the website so you guys can enter it. But if you don't, and if I don't get that built into the website, we have to transcribe, copy, paste 300,000 times. Do you know how much work that is? That takes time to do that stuff. So I think a 1 year time frame is pretty reasonable for filing.
Yeah.
And another year to work through the legal process.
Right. Remember what we were talking about Monday night? I'm going to be going around the state of Florida with this book, right? And this is a notary journal, right? This is a legal document. So I'm going to be going around the state of Florida here once I get things settled. And I'll be setting up. It'll be kind of like a book tour. If you want to come and, meet us somewhere and come and sign up for it, I'll have my notary stamp, and you will get a stamped copy of a Florida, it's called a Florida short form. Okay. That says that you signed up. You'll have this. There's a receipt to take with you that shows that you signed up. That's why I said this stuff. I've already gone and I've already bought all this stuff. You guys don't need to supply this. I've already done this. So when it comes to doing this stuff the proper way, again, this is just us doing what we do. We know how to do business. So I've had these forms and stuff, been doing it for years. So the sooner we get closer to actually filing is you'll start seeing posts from John and Kirk and myself that will be, I myself personally will be traveling around with my notary kit and my receipt books and stuff. So if you guys want to join and come and do a meet and greet, do face-to-face, get a copy of what we're working on to take with you, I'll have the printers and stuff. And, only thing I'd ask is that you just, if you want anything extra, it'll be there to provide. Just, help us restock the paper and the ink and, or the toner or whatever it is we're going to use. Other than that, that's all we care about. That's all I care about. I know John, Kirk, same thing. So,
okay, so let's bring Margaret on. She's patiently been waiting over here. So
that's why we love Margaret.
Thank you, Margaret, for calling. Welcome to the show.
I have an important question to ask you guys because I'm having a dilemma with us. He cried to the court that I wasn't serving him with papers because he's in Indiana and I'm in New Hampshire. So I've been sending them certified mail. Now he's refusing service. I've got 15 days to send this guy interrogatories. Now I have to send everything by the sheriff, which is an out-of-state service, which costs me $70 a pop, which is the only way I can get paperwork to him. And what they're basically trying to do is make me broke because they know I collected disability check. Now they want 2 copies of everything, and they put it on the docket for a final hearing for July 5th, when I've been going to court since 2004. Now they just want to squash the case because I publicly exposed them on Facebook.
Right.
Well, so how do you, when you can't serve somebody, how are you supposed to get due process?
Well, the answer is in the question. Service by certified mail doesn't require a signature. A lot of people use that green card because they think it's necessary. It's not. All you need is an address and I had an example. I posted it earlier for when of service that I've done. When you go in, you pay for priority mail, you get the tracking number. All you need for proof of service is that once you have their original signature that they've been served copy of the case, once that's going, all you need to do is do priority with a tracking number. That's all you need. You don't need any more than that. Anybody tells you otherwise is wrong.
To me, though, unopened. So that means he wasn't served because he never bothered to open it. It's getting returned to me.
Now, here's another thing.
It's okay. All you have to do is show that you served it, right?
And
here's another thing.
Address, that's on you.
Does everybody realize that the mail service has now, they are now photoing every single piece of mail that comes through the mail, and you can actually go online and register to see what kind of mail you're going to get for the day.
Get out of here! I didn't know they did that.
Priority mail is mail is just as good as that green card return receipt.
And yeah. I addressed this with I spoke with Margaret on the phone. I think it was last night, and if the recipient is not accepting the mail, it doesn't matter. But as an extra step, send it certified mail, not return signature. Just send it, and the green card shows proof of delivery or attempted delivery, and you can show. And so I think You know, we talked about that last night, Margaret. Send it certified mail with and get proof of service with the green card, and then attach that green card to a proof of service. I think I sent you a proof of service through Messenger that you can attach and file in your court.
Yeah, but the thing is, he's not going to answer the interrogatories when he hasn't answered the last set with the attorney. They never gave him a contempt for that, but they threatened me with a contempt for not serving him.
Well, that, you know, if they're, you know, then it gets into, you have to go, I mean, they're bad actors. That's what they do. They pick a party that they're going to side with that's going to generate the most litigation and the most revenue for the state. That's their purpose. And you're not going to find justice in there.
Back to that money.
Nope.
What you can do is build your facts and take it to federal court. And the federal courts are generally corrupt as well, to be quite honest. But at least you got a fighting chance. And I think the federal courts are starting to turn. I really do. I think that they're starting to adhere to the Constitution. So you stand no chance in state court. They're corrupt.
No, I haven't got justice since 2004 there. Now they want to squash the case completely and wash their hands of it.
Yeah, the single purpose of the state court is to generate revenue for the state and for the attorneys. Nothing to do with justice. You are not going to find justice in the state court. At least you got a chance in federal court. Yep.
You're there in the state court to do one thing and one thing only. Establish your record. Get it on file, right? Yeah. That's the only thing you're there to do, because when you go up to the higher court, they're going to say, we never said that. Yeah, yes, I do. Not only is it on the record, I can show you when and where and how and what date it was filed. So don't tell me it wasn't on the record. It's there. You know,
it's crazy. They're altering documents already.
And well, yeah, then you need to go pick up a dictionary.
Yeah, I don't.
What about the Human Rights Commission? What do you think of that? As a disabled person, and they're doing ADA violations. What about the Human Rights Commission? Is that a waste of time, or is that any good?
Well, I'm going to tell you right now, as far as the agencies are concerned, there's a reason that these reports are titled Weaponized Family Court. Okay, the reason they're called weaponized is because that's exactly what they've done. Is they've taken these agency processes through these guidance documents. You've heard us discuss that problem, right? Solve that issue back in November of 2017. Here's the problem. A lot of those old guidance documents are still hanging around. They haven't cleaned it all out yet. That's why I said, you know, when we do these things and we go back in and have to redo these processes with these agencies and basically put them in their place, it takes some time not only to change the paperwork, but there's also the mindset of the actors that are actually employed. So, and you can't just walk in and fire an employee. You have to give them, you have to be able to show that you've at least attempted to train them. So if you can demonstrate that you've tried to train these people and they're not accepting the training in the proper process of law, then you can let them go. But even that's a process. Hiring and firing is not just walk in, okay, you're fired. You know, it takes a lot to be able to fire somebody. So
I'm just going to hit a really quick question that was in the feed. What if there's no district court nearby? There's 94 district courts in the United States. Tennessee, I think we've got 2 or 3 here in Tennessee. They're generally within a couple hour drive. I recommend driving there and getting file stamped copies of what you file. But you can mail your complaint into the district court and they will file it. And then I posted a motion for CM-ECF. Filing privilege, which is electronic ECF, or CM-ECF. CM is case management. ECF is electronic case filing. So CM-ECF, and you can file your documents from your home computer with that. Some district courts, the more corrupt ones, do not allow pro se litigants to file electronically. But if you motion the court, you generally get them to do it.
Yeah, I'm not that good with technology. My son helps me with that. I used to do everything by hand.
Yeah, it saves the electronic filing with CMECF saves you a ton of money. You don't have to notice opposing parties. You can just send it in through CMECF, and on your certificate of service, just write in there that the parties will be noticed electronically through CMECF, and you don't have to mail it to them like that. So it saves a ton of paper and ink. I mean, it's the way to go is electronic filing.
So there's another question here. Can I file in Maricopa if the state court case is in Pima? Wherever the case is at under that county, okay, that's the county court you have to file in. You can't file in another county court. You have to file it in the court that you're in, that the case is in. So just let everybody know we're down, 15 minutes? We have 15 minutes left here tonight. And,
I got one more question for you. Now, this is what the clerk's office. The clerk's office is limiting my pleadings to 4 a month, and they're saying that some stupid family court rule that I have to attach all my evidence to affidavits. So they returned everything to me, but they refused to sign the letter that they sent all this stuff with. So does that make it valid when there's no signature on it? The lady's like, oh yeah, my initials are on there, but there's no signature. How does the clerk's office limit your pleadings? Isn't that against your First Rights Amendment of redress to the government and free speech?
Yeah, we talked about this also. So from what I understand from Margaret, from our conversation last night, is that they have a local rule in her jurisdiction that they will not accept a filing by a pro se litigant unless it has an affidavit attached to it. And so I sent you a copy, Margaret, of
yeah, my son's going to print those out to me tomorrow, but I just want to know if there's validity to what they're doing, limiting my pleadings as well.
So when they deny access to the court like that, and attorneys can file with a signature, and pro se litigants have to file with an affidavit, that's unconstitutional. It's monopolistic, violation of the Sherman Antitrust Act. But it's a denial of equal access to the court, and denial of the process. Do they care? They don't care at all.
Which by definition is an unlawful emolument. So if you wanted to call that what it is, because it's an unlawful advantage, in law, it's an unlawful emolument, right? So we talk about the proper nomenclature and the proper verbiage, proper usage for the term. If you walk in and tell them that these artificial advantages you're creating are unlawful emoluments, you're going to watch their eyes get about that big, because two things are going to happen. They're going to know where you got that.
And I think you can argue that it's also a violation of equal protection of the law.
Exactly. It would present a 1983 case, cause of action. So
I want to address Tiffany Thornhill here. She's talking about moving forward, we need petition ballots to gather signatures in our states and counties. Well, we're using, John just started the website. Okay. So the website is up to register for an email to get notified. And all we're doing was we're collecting names. You'll be a co-plaintiff in this class action lawsuit.
And let me share my screen on that real quick. Do you mind?
Yeah, go ahead. So
hopefully it's not
we don't need any of those petition ballots and to gain signatures or anything like that. So this is all going to be straight through the petition.
So this is the new website that we created for the purpose of collecting email addresses. And then when I have your email address, we're going to contact you for your legal name and everything else that we need from you to make you a co-petitioner in this case. So the website here is we the people v50.com. We the people v50.
Hey, flip your screen. Can you flip your screen? Because it's backwards online.
It's
how do I flip?
I have no idea.
Is that on your side?
I'm looking at Facebook on my laptop over here, my second laptop.
How did that happen?
Yeah, Facebook, it all ass backwards.
Does it look okay on yours, Kirk, or is it backwards?
No, it looks okay on that laptop over there doing the Zoom, but out here on Facebook land on the video backwards.
Even if it's
Zoom okay.
Hold on. There it goes.
We go.
It fixed itself.
All right, so
love you, Ted. Thanks, brother.
So if you go to the website here, wethepeople50.com, and you scroll all the way down to the bottom, it says become a co-plaintiff. And I put co-plaintiff because I think people misunderstand when I say co-petitioner, like we're signing a petition. Technically, it is a petition to the court, and you're going to be a co-petitioner on the complaint. But I think people understand easier as co-plaintiffs that you're bringing a lawsuit. So down at the bottom, I have become a co-plaintiff. You type in your email address there, and we're going to contact you and say, you're welcome to be a co-plaintiff, co-petitioner on this case. And just send me the information I need, and your name will be in the United States Supreme Court.
Okay. We have a caller.
Yeah, I was gonna bring him on real quick. We're down 10 minutes. All right, so let's see what we got here. 9709. Welcome to the Kirk's Law Corner Wednesday night call-in show. Do you have a question for us, and who are we talking to?
I think
that caller left already.
What? I just unmuted him.
Yeah.
What the heck? Okay, then. Well, that ends that. So, all right. Well, let's kind of start our closing here, because we have the time and we're right here. So, last minute stuff. John Gentry, shoot.
I am excited about the change that I think is coming to this country, and go out and tell everybody about this original jurisdiction case in the United States Supreme Court. We are demanding reform. This is a right guaranteed to us in our Constitution. The Supreme Court has to hear this case. And we're going to do everything that we can to make sure that this gets in there. The only thing you got to do is go to wethepeople50.com and type in your email address at the bottom, and you can become a co-plaintiff on probably, I think, the most important case ever filed in the Supreme Court of the United States. So get out there, tell your friends. This is not just about Child Protective Services. It's not about family court. This is about preserving our right of due process. And if we don't have due process, we cannot protect free speech. We cannot protect the right to bear arms. The due process, in my opinion, is more important than a right of free speech and a right than a right to bear arms. There's nothing that's more important. It is the only right that is stated twice in our federal Constitution. And it is restated in our state constitution. And we must fight to preserve this right. And I think that what we're doing in wethepeople50.com is the way to do it. And there's a Facebook group called We the People versus the 50 United States. And I keep people posted in that Facebook group. It's a secret group. So you have to be invited. So find somebody that's in there and get invited into the group.
All right. Thank you, John. And Chris, last minute stuff. What do you got?
Oh, I just wanted to say thanks to everybody for dropping by. it's been this year. I thought last year was crazy busy. This year is just, like you said, it's absolutely nuts between, working full time and then doing this. I joke about working 184 hours a week or 184 days a year, 384 days a year. But, it really feels like that a lot of times. I'm up till 2-3 o'clock in the morning some nights, and then I'm back up again at 5:30, 6 o'clock. So it's just, it gets old. But, if I don't get right back to you, it's not that I'm ignoring you. There's a lot going on, and we're starting to we're getting through. Our message is getting out there. It's for example, my process has been accepted across the nation in multiple houses of Congress and multiple federal courts. And now it's just me educating them and making sure that they understand how it works. So, on that note, stop by, say hi to, the other groups out there, the Blog Talk, and, everybody out on there, and Spreaker, YouTube. I mean, take your time, do your, listen to stuff in the car when you're driving around or whatever. But the best thing you can do to help yourself is, watch some of our old videos. I've got some short 10, 15-minute stuff in my kids group, Amber and Steven. Just basic stuff. But that's the best thing you can do is just, arm yourself, learn, some of the key words, because those key words are your main defense. So other than that, I'm back to the grindstone, and I guess we'll see you guys back here on Monday, unless we get breaking news.
And I'd give a shout out to Jay Moss's show. They're doing some awesome stuff over on the Far From Normal radio show. So, when we're not, I think we're on different nights. So get on Jay Moss's show. They have awesome guest speakers on there. Those guys are really knowledgeable about what's going on in the state courts. So they've got a great show too, and we love those guys over on Far From Normal radio show.
Yeah, I was going to mention something about Jay's show, so as well. That's Tuesday nights, 6 to 8 p.m. Mountain Time, 7 to 9 Central, and 8 to 10 Eastern. So, yeah, Jay Moss, the Far From Normal.
I wanted to say hey to Bud Vino since he popped in earlier and said hey. So, what's up, brother Bud Vino? Yo, yo, yo.
Yo, yo, yo. So
that's it. That's his signature entrance.
My final for the night is I'm hot, I'm tired, and I'm hungry. Because I get off work, walk across the street, change my clothes, and come down the street and hop on here. So I don't get a chance to eat anything, and sometimes you'll see me eating some chocolate stuff here, trying to get myself a boost of sugar or something to keep me going. But I want to thank everybody for tuning in, for sharing this. Like, follow, and share Kirk's Law Corner. Get in there with the We the People group. That's a private secret group. We got to have a friend that's already in there to get added. If you're not friends with anybody in there yet, you probably will be by the time this gets closer. But if not, send one of us a friend request. Send us a message, maybe, letting us know. I put it out there on Kirk's Law Corner to itemize people who want to join that as well. I put it on my public profile. I'm starting to share it in groups as well. So this thing's going to get big. We need it to get big. So, just think about this. We're around a little over 10,000 people now in 4 weeks, right? So now if we just had each and every one of you, 10,000, invited one person into that group, we could grow that group in one day from 10,000 to 20,000. And then the next day, all you got to do is invite one person. We go from 20,000 to 40,000 in one day. So, share. Let's get this out there. This is us exercising all political power is inherent in the people. In order to properly exercise that right, we have to come together in mass numbers. Okay, we can't just have a couple thousand. We can't have 10,000. We're gonna need 250,000 people.
Mm-hmm.
That's what we're gonna need. And excuse me, I don't know what they're gonna do when we start itemizing each and every person's name on the petition as a co-plaintiff, as a petitioner. But we're not going to take no for an answer. All of us are not going to take no for an answer. So we have that right to demand reform. So that's what we're doing. We're going to make it happen. We all are. We're all going to make it happen. So much love to you folks out there. Pick up that torch of liberty. That's what this is about. Life, liberty, and the pursuit of happiness. If we can't unite under that, I don't know what we can unite under. So that's it right there. Life, liberty, and the pursuit of happiness. If your life and your liberty and your pursuit of happiness has been infringed upon through unjust proceedings, unlawful due process of law, just any of it, color of law, whatever. Not just family court, it's everywhere. So there's plenty of people that haven't even been affected by family court. So this is huge. This is we the people versus the 50 corrupt United States. And we are coming. Much love to you, my brothers and sisters, my brothers over there. And thank you, Ted, for producing the show here tonight. And we will see you Monday.
Love you guys. See you then.
I don't know if Ted was prepared for us to close like on time tonight.
Kept saying, wrap it up, shut up. Oh. Sure, somebody was. I kept seeing the little thing come across the screen.
Yeah, Ted was sending messages to me erroneously.
Are we still live?